Good morning. Actually, multi number of times all the courts, including Supreme Court, has categorically held that children never be illegitimate. But unfortunately, uh, the Supreme Court door was knocked to remove the word itself, which was contained in so many acts, and particularly Hindu Succession Act, Section 6. So once the court holds that children may not be illegitimate, only parents may be illegitimate. So that area should be swept out. The word itself should be removed. That's what my. Here you see very unfortunate judgment. You must all should know how this case was dealt by Division Bench of Chhattisgarh High Court, AAR 2023, Chhattisgarh 63. AAR 2023, Chhattisgarh 63, Basanti Boy versus Ajit Kumar Bhatt. Here, the history is most important. Basanti Boy was wife of late Ganesh Prakash Bhatt, who was working as irrigation department. He married and had two children, one son and one daughter. The Ajit Kumar Bhatt happens to be a son of another wife. So when they all are claimed compensation, there was some compromise effected. Accordingly, the son of legally wedded wife was appointed on compassionate ground. But at the time of that, there was a declaration by Ajit Kumar that he would maintain his another brother Praveen Kumar and sister Santoshi, and will take care of his mother Ramkali Boy also. But later he did not keep his promise. Therefore, the second wife's son filed a case. Second wife of Ganesh Prakash Bhatt, late Basanti Boy, along with two children, Praveen Kumar and Kumar Santosh. He stated that the application was filed under Hindu Maintenance and Adoption Act, Section 21 and 22 of that. That was the unfortunate mistake committed by these poor people, because the section Hindu and Maintenance Adoption Act was very old act. That act was intended when much of maintenance cases were not filed. Here you see, unfortunately, Section 21 defines the dependents. There they say about sons, including minor illegitimate sons, remains minor, illegitimate daughter also. But Section 22 says, subject to provision of Section 2, heirs of the deceased are bound to maintain the dependence of the deceased out of the estate inherited by them from the deceased. So that was unfortunate. They have filed under Section 21 and 22. The Division Bench of Chhattisgarh easily held the income derived by the respondent's son, first wife, not amounts to estate. Simply they held. But this has to be revisited. The judgment has to be revisited according to me, because it's not seems to be good, because he has given a letter of undertaking and he did not keep his promise. Therefore, the question of denial of under Hindu Maintenance Adoption Act. But according to me, if I am correct, to my memory, which is being faded away slowly due to so many health factor and disturbances factor. I understand that the some of the judgments, particularly Kerala High Court, held that uh, the if a person who's obtained compassionate appointment must maintain the entire family, because for consideration of maintaining the entire family only the appointment was given. Therefore, if suppose you may say the court may say that it's why you have filed under Hindu Maintenance Adoption Act, but multi number of judgment also says that even if they did not file application, even if they file application under Hindu Maintenance Adoption Act, the court, because it is a family court, may exercise 125 CRPC and award maintenance. Here it seems, but fortunately or unfortunately, court, the division bench and the family court judge seems to have weighed that there was some settlement of monetary benefit. Therefore, by weighing that in the scale, they seems to have they denied it. But once the court verdicted a ratio, so that may affect a multi number of persons. So, by reading the judgment, I think I have read it. Again, I will read it once again. AAR 2023, Chhattisgarh, page 63. AR 2000 Chhattisgarh, page 63. Basanti Boy and other, and versus Ajit Kumar Bhatt. So only the judgment you have to take care of that. But by referring the judgment, I would like to draw the attention of legal luminaries and my lord's assistants, PAs who are following this video from time to time, and the registry who is also strictly following my this video communication should approach law ministry or by filing bill that the word itself should be removed. The illegitimate children, wherever it applies, it should be removed. Instead of illegitimate children, just like you are mentally retarded, you are substituted, physically handicapped, you substituted by physically challenged, mentally challenged. Like that, instead of illegitimate children, some other word should be incorporated, so that that very word itself insulting and somewhat psychologically affecting the children. This is, but you cannot prevent. You know one thing, for you, all of your kind information, before into Marriage Act coming into force, at the effortful instance of Dr. Ambedkar, the Hindus can marry any multi number of times. Only question of form of marriage, if disputed, that a wife may be treated as concubine. Or if she is already married, even if you marry second time by rituals, that marriage is not valid. Therefore, she will also be treated as concubine. Only Gandharva form of marriage was not recognized by Hindus, except tribes. Tribes only alone recognized the Gandharva form of marriage. So, for all these things, I would like to use any substitute word for illegitimate son and illegitimate daughter. And of course, illegitimate son and illegitimate daughters are entitled for maintenance till they attain age of majority under 125 CRPC. But the courts can still exercise, because it is a family court, can exercise instead of Hindu Maintenance Adoption Act, at least for the reasons that he has given undertaking. Law of equity come to rescue, Otherwise, this is not seems to be correct. But there are several other judgments also, which I would like to discuss later on. Best wishes.